I think we'll get started. I'm not going to take much of your time. I'm going to very briefly make a couple of remarks. First of all, you're about to hear from two of the great lawyers of our time, and they have a lot of important things to say. They care very much about the law, and they also care a great deal about things that are good for our country and for our society and for the rule of law. And so I thought it appropriate to ask George to make David's introduction, because I think he will do a great job of doing that. But I also think we can recognize the fact that he is also someone who will speak out for what he believes in. George, as you may all know, most of you know for sure, has for a number of years been a leading lawyer at Wachtell Lipton. He is recognized as a great legal mind, and he has spoken out at times when it's not always easy to do so. So let me introduce George, and George will introduce David. Thank you very much.
Well, I want to thank Greg for giving me about the easiest task imaginable here today. Normally when you attend one of these things and participate in a panel and one of these events, you actually have to do work. You have to read cases and you have to prepare to answer questions. And this doesn't really require work, because introducing David Boies is pretty easy, because you all know who he is. He's one of the greatest litigators of our times. If we were all here playing Family Feud and the question were, hey, name a litigator, name a great litigator, name the greatest litigator, the number one answer would probably be David Boies. And the number one answer, he wouldn't be just the number one answer here now in 2019. He was the number one answer when I graduated from law school 32 years ago in 1987. I was reading stories about him when I got out of law school and started practicing law, legendary stories about how he had a craps table in his office for a desk, and how he charmed juries wearing his Sears Roebuck off-the-rack suits, which maybe that one is, they're still here today. And of all the great cases that he litigated, United States against IBM, which lasted probably, how many years? 12, yeah. Westmoreland against CBS, one of the truly great libel cases of all times. He then, in the 90s, represented the United States Department of Justice in a case against Microsoft. The United States Department of Justice hired a lawyer. This guy. That's not the usual course of events. He then, he isn't just a trial lawyer. He argues in the Supreme Court. He argued Pennzoil against Texaco, Bush v. Gore. He litigated Hollingsworth against Perry, and then closer to our hearts, Halliburton against Erica P. John Fund, which preserved, and all you plaintiffs' lawyers should be standing up and giving him a standing ovation, preserve the fraud on the market theory of reliance, without which Rule 10b-5 class actions simply wouldn't exist. Now, you could have a day-long event just talking about the cases he's litigated. He has just had a remarkable career. He started out as a partner at Cravath, and then he created his own national law firm that is just an utter powerhouse. And somehow along the line, he managed to serve a stint as chief counsel of the Senate Judiciary Committee. On top of all that, he's a winemaker. Seriously, he has a vineyard. He's a winemaker. He's also an author. And he's also a thinker, which is why we have him here today. He's going to give us some thoughts about the rule of law and how the rule of law intersects with securities regulation. And the rule of law is a subject that we all are thinking a lot more about today. It's something that we probably, as lawyers, have taken for granted too much in the past. We're thinking about it obviously a lot more today because we have a chief executive, frankly, who doesn't quite fully understand the rule of law. And somebody who would say things like criticize an attorney general for allowing the prosecution of Congress, members of Congress from his own party, and criticizing the attorney general for allowing that because it would adversely affect the president. Well, that's something that's not consistent with the rule of law, not consistent with any public official's oath of office. It's something that we find as lawyers profoundly disturbing. But I wouldn't put some people put a very negative spin that there's some imminent threat to the rule of law, and I don't quite view it that way. I think the rule of law is what protects us. The checks and balances actually have protected us, because that said chief executive was reduced for 2 years for tweeting at the attorney general, pretty lamely, in fact. And then when he ultimately got rid of that attorney general, he was forced to nominate someone of such stature and of such principle that the new attorney general, the nominee, testified at his confirmation hearing that if a president were to intervene in a matter that affected him personally, that would be a breach of duty, which I take to mean something that could possibly cut the chief executive's term short. So we should be grateful for the rule of law. The threat to the rule of law in the current circumstances is the corrosive effect of things that have been said by people in high places. And that's where all of us come in. We all need to think about it and speak out, regardless of our political persuasion. And we also need to think about the rule of law as it affects our daily practices, which is why we're here today, and what David is going to touch upon today, because it does intersect what we do as lawyers on a daily basis. In the realm of securities regulation, I think of the rules on insider trading. We have these complex set of rules, which seem quite sensible, about when you can trade and how you can trade and what information you can have when you trade and how you can obtain that information. But you won't find those rules in the United States Code. You won't find those rules in the Code of Federal Regulations. You won't find those rules in 17 CFR 240.10b5. They come made up in case law after the fact by judges. The judges may be right, they may be smart, and they may be sound thinkers, but they're making up the law after the fact, and people are going to jail for it. Is that consistent with the rule of law? That's something to think about. And there are other issues that relate to the rule of law that intersect with securities regulation, and David has a number of fascinating thoughts about those, and he's going to give them to you now. And without further ado, I present to you David Boies.
Thank you very much. There's probably no principle that is more important to our legal culture, and I would say more important to the American dream, than the rule of law. The rule of law is something that is of critical importance to us in and of itself. It says that the rule that's going to be applied to citizens will be a rule that's reasonably predictable in advance, that it has been established consistent with constitutional norms, and that it will be applied fairly, regardless of the identity of the party to whom it is being applied. That kind of protection is not only essential to individual liberty and to commerce, but it protects all other individual rights. Without the rule of law, you have no certainty as to what the government can do to you at any given point in time for any given reason, under any given circumstance. Our founders did not invent the rule of law, but they made two critical contributions to it that are now so well known and so well copied around the world that it's sometimes easy to lose sight of them. The first contribution was a written constitution. There are so many written constitutions around the world today that it's easy to forget what a radical idea it was in the 1780s to actually have a written constitution that was written in such a way that it was extremely difficult for any majority to later change. But that concept of a written constitution with fundamental rights that were put beyond the reach and fundamental procedures that were put beyond the reach of any future majority is something that was essential to the rule of law, because what it said was there are certain procedures that guarantee the fair application of the law that Congress can't take away from you. You can get both houses of Congress and the President of the United States, and they still can't take those rights away from you. And that there are certain fundamental substantive rights: freedom of religion, right of free speech, freedom of the press, right to be secure from unreasonable searches and seizures. All of these rights are again taken and put by the rule of law beyond the reach of any temporary majority. The second contribution that they made was the contribution of an independent judiciary. And again, it is easy to take that for granted today. It's easy to forget what a radical idea it was in the 1780s to establish judges that were given lifetime appointments whose compensation could not be reduced during their time in office, who were given the power to make the most important determinations in terms of not only interpreting the laws, but interpreting the Constitution, which is to say, interpreting the extent to which Congress and the President could change or enforce the laws. And judicial independence has been a cornerstone of the rule of law, and it is something that has been, over time, frequently under attack. And I would suggest it is no more under attack, and no less under attack today than it ever has been in our history. And those attacks are sometimes obvious and sometimes less obvious. When the President of the United States attacks a judge because of the judge's ethnicity or because of who appointed the judge, that undermines the rule of law in the sense that it undermines the independence of the judiciary. And I think we can all applaud the Chief Justice's response to that when he said, aspirationally, if not factually, there are no Obama judges, there are no Trump judges, there are simply judges. The problem, and this is why the attack on judicial independence is sometimes not as obvious as might be desirable if we were able to combat it, is that increasingly there is a danger that we will have Obama judges and we will have Trump judges. The same Chief Justice that gave us those remarks is the same Chief Justice that now presides over a Supreme Court that increasingly votes 5-4 along party lines to uphold decisions of a political character. That division, and that is not a problem of this administration. That is a problem that has been created by a series of administrations, and it is a problem that is created when we attach a litmus test to our judicial appointments in which we are more interested in how they are going to vote on critical issues than we are on how they are going to interpret the law. And I think that the rule of law suffered two important blows over the last 2 years. One was the politicization of the confirmation process, where the Senate of the United States refused to even give a vote for confirmation on somebody who was unquestionably one of the most qualified people to be appointed to the bench. I think the second was when the rules were changed in the middle of the game to enable the confirmation a year later of a political appointment by a simple majority. The more we go down the road of politicizing the appointment of our judges, the more the danger is that there will be both an appearance and perhaps even a reality that we do have Obama judges and Trump judges and Bush judges and Clinton judges, or judges of whatever the president is going to be in the future. And that is a danger to the rule of law that is as great, in my view, as the danger that comes from the kind of attacks that are more obvious, but I think no more threatening to judicial independence. My task today is to talk about the rule of law in the context of the SEC and securities regulation. And I will do my best to stay to some extent within that lane. I do feel a little bit like Noah's neighbor who employed him to stop building his ark and help fix his leaky roof. It is with a certain amount of difficulty that I pass discussions about the Supreme Court's action yesterday in terms of reinstating, in effect, President Trump's rule with respect to transgender in the military and the implications that that has for the rule of law. There are many areas in which the rule of law is under assault, and it is with some attempt at discipline that I will focus my remarks for the most part on the SEC. That has a couple of virtues. One of the virtues is that it helps understand the rule of law in an important context, and it is a context in which, perhaps unlike the broader societal canvas, is an area in which the rule of law is actually having a resurgence. There is much more interest in issues relating to the rule of law in securities today than there have been for many decades. For roughly half a century, beginning shortly before I entered law school, the courts had simply assumed that whatever administrative agencies did, at least within a very, very broad perspective, was going to pass constitutional muster, was going to be consistent with the norms of the rule of law. There has been an increasing willingness, both on the part of administrative agencies themselves and perhaps even more important because of their role in our society on the part of the courts to re-examine some of those assumptions. And I want to talk about 4 of those areas this afternoon. One of those areas has to do with how judges are determined within the, for example, Securities and Exchange Commission. What is the proper role of those judges, and how does that role comport with the Constitution? Thus far, the courts have sort of nibbled around the edges of this issue. There was, as many of you will recall, a decision by the United States Supreme Court last June in which the court invalidated the appointment of the administrative law judges at the SEC on the grounds that they had not been constitutionally appointed. That was, Justice Breyer characterized as a technical constitutional issue. I'm not sure there are such things as technical constitutional issues, but I know what he was talking about in the sense that what the court was saying to the SEC was that you can't have administrative law judges appointed by the staff. They've got to be appointed by the commission. Now, of course, the result of that is that the staff will come up with a series of recommendations. They'll give it to the commission, and the commission will now appoint those people. So the net result may not significantly change either the identity or the character of the administrative law judges. But it is an illustration of the willingness of the courts to begin looking at these kind of issues from the standpoint of whether they are consistent with various constitutional norms. Now, the norm that was involved there was the constitutional requirement that so-called inferior officers, by which is meant a government official that has a certain degree of discretion and power, have to be appointed either by the president, by the courts, or by the head of departments. So they couldn't be appointed, for example, by the staff of the SEC. But there are broader questions that go to the application of the rule of law in terms of adjudicatory decisions at the SEC. We all remember that Article 3 of the Constitution says the judicial power of the United States shall be vested in a Supreme Court and such inferior courts as Congress may establish. And then it goes on to provide various protections for those judges. The question is, what is the judicial power of the United States? When does an administrative agency like the SEC begin to exercise the judicial power of the United States? Now, the SEC can, of course, as an enforcement agency, go into court and ask a court to, for example, issue an injunction, make a finding, impose a fine, impose an injunction. In that case, the SEC is acting as an enforcement agency, and the court is exercising the judicial power. However, what happens when the SEC in an administrative proceeding issues, for example, a bar order, which is essentially an injunction, and a pretty serious injunction at that, because it can deprive somebody of their livelihood for years or maybe for the rest of their life? Is that an exercise of the judicial power of the United States? Is a injunction that is in effect ordered by the SEC through an administrative proceeding, any different than an injunction issued by courts. In fact, what we've seen over time is that SEC enforcement actions that would have in the past gone to the court are now going to administrative law judges. Is that consistent with the constitutional scheme? I think that is something that the courts are going to increasingly be called upon to delineate. And I think that the answer is not a clear answer. In my view, there clearly are actions that administrative agencies take today that are within the judicial power of the United States. There are probably also some actions that are not. How you define that, where you draw the line, is going to be a difficult process. Before you get to that issue, though, you're going to have to wrestle with fundamental constitutional questions as to how do you define the judicial power of the United States, and how do you define what the role of administrative agencies are in enforcing those rules. A second aspect where I think the rule of law comes into bearing with respect to securities regulation in the SEC has to do with the extent to which the law requires that the rules that are going to be applied be relatively definite. Increasingly outside of the administrative context, courts are finding more and more laws constitutionally defective because of their vagueness. The vaguer a law is, the less a person is on notice as to what that rule is going to be, and the less that you can say that you are applying the rule of law. Vagueness is, at the extreme, inconsistent with the rule of law. And courts have been increasingly prepared to recognize that outside of the administrative context. To what extent the courts are going to be prepared now to turn the analysis that has been developed outside of the administrative context to the administrative context is something that I think remains to be seen. Analytically, again, the impact on citizens of administrative proceedings can be just as great as the impact of a court proceeding. The deprivation of rights that can result from an administrative proceeding can be just as severe in many cases in terms of their economic impacts as the deprivation that comes from a court proceeding. So if you think about the importance of a reasonably knowable, predictable rule as part of the premise of the rule of law, and you apply that to the administrative context in which rules are sometimes written almost, it seems, with a desire for vagueness and generality. You can see that there is ample room for the development of jurisprudence that limits the vagueness of administrative criteria based on the same kind of rule of law considerations that has been done outside of the administrative context. A third area of in which I think the issue of rule of law in the SEC context is important, is in deciding whether the individual has a practical right and a practical ability to have a fair adjudication of the claims against the individual. And by that, what I mean is, the more the remedy or potential remedy is either A, uncertain, or B, within the discretion of the agency bringing the action, the greater the difficulty, the greater the practical difficulty there is in an individual actually contesting. If an individual does not have the practical ability to contest a charge, the rule of law breaks down, because the rule of law depends on the ability of an individual to have the fair applicability of the rule tested by a fair tribunal. And even if you have a reasonably fair tribunal, if the risk and consequences of testing a rule, testing a charge, are so severe that individuals can't take that risk. If you have a situation in which the remedy or the rule is going to be so much in the discretion of the, in this case, the SEC, the Commission, if following a ruling, the remedy, the extent, for example, of the bar may be so great that you can't risk taking it to trial. That undermines the rule of law. Now, outside of the administrative context, courts have wrestled with this in the context of where prosecutors overcharge so that a individual is faced with a prospect of a dozen or 15 counts, each of which could end up with a successive sentence if convicted. And that is used then as leverage to extract a plea deal to avoid a trial. Courts have begun looking at some of those kind of potential abuses, and the same thing can be applied in the administrative context. The fourth area is closely related to the third, and that is where the agency is given essentially criteria-less ability to either grant or deny relief. For example, if there is a successful SEC prosecution, that can result in a series of disqualifications that the Commission has the power to waive. There is no enforceable criteria that cabins how that discretion is exercised. That power, that essentially uncabined and unreviewable power, gives the Commission, gives any administrative agency in that context, the ability to exact concessions, exact agreements, exact plea, in effect, plea agreements. Again, all inconsistent with the rule of law. I also want to spend a moment following up on the comments about insider trading, which I think illustrate how all four of these areas in the application of the rule of law to SEC enforcement and regulation tend to come together, because you have a situation in which you have very vague and uncertain and unspecified standards. You have standards that have not been established by any normal set of constitutional norms. The legislative power of the United States is vested in Congress. Congress didn't pass the rules that are being applied. The rules are essentially developed on a case-by-case basis. Sometimes not at all obvious what rule is going to be applied until a court or the SEC announces it. It is in an area in which the SEC enforcement is not always entirely intuitive. And it is in an area in which there can be significant policy disagreements as to what the right rule is. In the usual insider trading case, what is at issue is somebody finds out material non-public information and then trades on that information. Now, that is, of course, what everybody tries to do all the time. And the question is, what are the limits to which you can go in order to get that material non-public information? And what those limits are not always clear, they are not always intuitive, and they are not always consistent. And if you think about what the purpose of securities regulation ought to be, is securities regulation is designed to make capital markets efficient. In order to have efficient markets, you must have two major criteria. One, the markets have to be competitive. And second, the participants in the market must have reasonable access to information. Information is a critical component to efficient markets. Originally, the SEC and the securities laws were designed to make sure that the information that was presented to the public was accurate information. That is, people were not supposed to make things up about their companies or about their prospects. They were not supposed to lie. That is intuitive, and it is quite consistent with what the purpose of securities regulation and the purpose of markets should be, because you want to have accurate information, you want to suppress inaccurate information. But securities regulation didn't stop at making sure that statements that were made were accurate. The next step moved towards trying to ensure that the information that was offered was adequate. Not really accurate, but adequate. And so people were told not merely you can't lie, but in addition, you've got to disclose certain things. That is, you've got not only to be accurate in what you provide, you must also provide a certain menu of information. Up to a point, that also can be viewed as consistent with the purpose of increasing information and increasing the efficiencies of capital markets. Although you have a trade-off in terms of the cost and burden of providing the information compared to the marginal increase in market knowledge. But again, securities regulation didn't stop with providing adequate information. It then moved to filter information. That is, there was some information that people were told you should not provide, or if you do provide it, you've got to provide it in a particularly secondary way, so that decisions that had previously been made by a company's management as to how to present their financials were in the interest of uniformity and adopting the kind of presentation that the SEC believed was most desirable. We're told that you now had to do certain things in certain ways, sometimes with quite unfortunate consequences, as anyone who went through the 2008-2009 financial crisis that was, in some people's view, including mine, greatly aggravated by the mark-to-market approach of the SEC, in which securities that companies had no interest and no intention to sell before maturity were forced to be mark-to-market, greatly increasing the volatility. Now, this has been something that has been the movement of what the SEC has done has not been for necessarily bad policy reasons. I think people can debate the policies that are at issue. But the question for the rule of law is whether those approaches are approaches that ought to be done at an administrative level, or is this something that, consistent with the rule of law, ought to be something that goes through the constitutional process of enacting specific rules and regulations. And that process is not merely a technical issue. The legislative process is different than the administrative process. It requires consensus. It requires interchange back and forth. You have a variety of interests that are able to make their views known and force consideration. The administrative process, no matter how many times they allow public commentary, is nevertheless something that is driven by the agenda of the people running that administrative agency. So the legislative process is fundamentally different than the administrative process when it comes to establishing the rules that are going to be applied. And I think that particularly when you're dealing in areas like insider information and what the criteria is going to be, that is something that there is merit in having a greater participation by the bodies that the Constitution gives the authority of rulemaking. And that's particularly true because not only does everybody seek non-public information that's going to be material to evaluating securities, but we want them to do that. That is part of the efficient market. We want everybody out there trying to find out information that has not yet been made public. The vice of insider trading is said to be that somebody with superior information trades with somebody who lacks that information, and the person who lacks that information is disadvantaged. Every time there is a trade, when there is material non-public information, somebody is being disadvantaged. They don't know it, and the person being advantaged may not know it. But that disadvantage exists regardless of whether the buyer or the seller, as the case may be, knows that the stock is undervalued or overvalued. There is a moral sense in which maybe it is unfair for somebody with superior knowledge to take advantage of somebody with inferior knowledge. But the economic result is no different. Whether if somebody is selling a stock that is undervalued because the public does not know of a positive development, that person is equally disadvantaged whether they sell it to somebody who knows or doesn't know the positive information. Now, what that means is that you want to encourage people to get this information out. The more you restrict the ability of people to gain that information, and the harsher and more unpredictable the penalties are for trading on that kind of information, the more you're going to discourage people going out and gaining that, quote, unfair, close quote, advantage. This is not a situation in which there is advocacy for people going to company employees and bribing them to give out financial data a day before they're going to be publicly announced. But that's not what the typical insider trading case is anymore. It's much more complicated. It is much more a question of how much people are permitted to cajole, mislead, induce people to tell them things. The kind of thing that we lawyers do all the time when we're dealing with witnesses, that the press does all the time when they're dealing with potential sources. This is the way information is found out. And in the context of securities regulation, we have an incentive to have that information found out. Sometimes you can read some insider trading cases and it sounds like what people would like is if information, if there's material, non-public information that ought to stay secret. It shouldn't stay secret, it ought to get out. And the way you get it out, is by encouraging people to seek it. And the way you encourage people to seek it is incentivizing people to seek it. And the way people are incentivized to seek it is if they know that if they get it before somebody else, they can trade on it. And so the policy issues here are not all one way. And that is particularly the kind of situation in which I think the rule of law and the adherence to constitutional norms in terms of legislative powers counsels that it is desirable to have the kinds of rules that are going to be applied, rules that are legislatively determined and not administratively determined. I have managed to stay largely within my lane of dealing with the rule of law in the context of the SEC and securities enforcement. And I do think there is, as I've indicated, there is a lot of important issues that are percolating up and that we're going to, as lawyers, be dealing with over the next several years as the courts give greater and greater scrutiny to the extent to which administrative action in general and the SEC in particular comport with constitutional requirements of the rule of law. But I can't resist ending where I started, which is the importance of the rule of law, of having government officials that respect the rule of law, respect precedent, respect the criteria that are going to be applied and need to be applied, and respect the judicial process that is critical to a fair application of the laws. And that goes, as I say, not to any particular administration. There are things that this administration has done that I find particularly unfortunate. But the problem with the independence of the judiciary, the problem with having a judiciary that we have the ability to have our traditional confidence in terms of its neutrality, is a problem that this administration did not create. It is a problem that is shown by the polarization of the nominating and confirmation processes that we have gone through. And it is a process that creates the danger that if we don't come back to a more neutral way of selecting and approving our judges, that we will have not only the appearance, but the dreadful reality that it will be possible to begin to say, that was a Trump judge, that was an Obama judge. Perhaps that was a Elizabeth Warren judge, or that was a Mike Pence judge. That is corrosive to our society. It's corrosive to the rule of law. It's corrosive to our judicial systems. And all of us as lawyers, I think, have an obligation to speak out and to try to bring the process back to an era in which judges were viewed and in reality were less predictable. The more predictable a judge's vote is, the less we are saying that judge is going to focus on the cases before him or her. If somebody had said the decision to reinstate the Trump transgender rules was 5-4, everybody in this room could have named the 5 and named the 4. I suggest to you that is an issue that we have to deal with as a profession and as a society. Thank you.
Thank you very much, George and David. Really brilliant. We're gonna be starting the next panel in the next 3 or 4 minutes. So if you'll just bear with us while we switch seats, and I'd appreciate that. And very shortly.